Okay, I think we have a procedural matter to come up. Mr. Nelson, I believe you're.
Thank you, Mr. Chairman. One thing that we missed during the preliminary matters this morning was that I would like to enter on behalf of the Office of Regulatory Staff a stipulation regarding the depositions of Carlette Walker. The stipulation was entered into by Office of Regulatory Staff, Dominion Energy, as well as SCENG. Parties have all agreed that volumes 1 and 2 and all exhibits of Ms. Walker's depositions would be admitted into the record. I would ask that both the stipulation as well as the 2 volumes of the deposition and exhibits be entered in the record as the next composite hearing exhibit.
All right, we're just going to do the stipulation now, and then when we get into the proceeding, when your witness is supposed to be called, we're going to try to keep that in order so we can keep it in order with the court reporter.
Just to clarify, Ms. Walker is not going to be here because of the stipulation. She's unavailable.
Okay, we're going to enter the stipulation as exhibit number 10.
Mr. Chairman, yes, as we enter the evidentiary phase of the hearing, SCENG would like to remind the Commission that we filed several preliminary motions, motions for determinations as to legal matters and for the determination as to whether certain testimony should be admitted into the record. We would like at this point to express the fact that we continue to stand by the matters set forth in those filings. And we don't want to be in a position where our conduct with the witnesses is taken in any way to be a waiver of those positions or having abandoned them. Specifically, we filed a motion to indicate that as a matter of law, the Commission's decisions made in the 14 orders that have been adopted under the BLRA are in fact binding decisions that are not subject to being reviewed and overturned. Everyone had a chance to make their positions known about those, to present evidence, to cross-examine, to take whatever legal actions were allowed under the statutes and the provisions of this Commission. Those decisions were made. In some cases, the decisions were appealed all the way to the South Carolina Supreme Court. And we believe that those decisions have finality and are binding under doctrines of collateral estoppel and other doctrines. We have specified in the motions the specific testimony that should be stricken from the record based on that legal position. That's the pre-filed testimony. We want to be sure that that motion is still on the record. We expect that there will be the possibility of other parties crossing these witnesses and eliciting similar information, or there may be questions from the Commission that elicit similar information. We would prefer not to have to stand up, interrupt the proceedings, and object every time that comes up. So we'd like a standing motion as to those matters. It includes the question of the binding nature of the prior orders, whether or not the terms of Act 258 can be applied retroactively, the conduct that occurred before that act was adopted. It's our position that you can't change the rules after the game is over. And that's what we think some parties are saying should happen in this case. We are also have taken the position that the proposal that Santee Cooper has made concerning the fund that it wants to create of some $351 million is beyond the power of the Commission. So we understand people will make argument and raise questions about that in their testimony. We'd like a standing objection as to those matters so that we don't have to interrupt the flow of the proceeding in order to preserve our interest in those things.
Thank you, Mr. Ziegler. We understand that, and your standing objection will run throughout the proceeding. Thank you. Okay, Mr. Giles.
Thank you, Mr. Chairman. At this time, Friends of the Earth and Sierra Club call Dr. Mark Cooper to the stand. Dr. Cooper, if you come around.
Dr. Cooper, if you'll push the button on your mic, the red, yeah, and get it in front of you and speak. No, push it again. All right, you're on.
Oh, I see
that red one up there around the top.
Mr. Chairman, I hope I have my button on too. Here we go.
You're doing well.
Thank you, Mr. Chairman. Dr. Cooper, would you tell the commission your full name, please, and where you live?
My name is Dr. Mark Cooper. I reside at 504 Highgate Terrace in Silver Spring, Maryland.
Did you cause to be prepared pre-filed direct testimony of Dr. Mark Cooper consisting of some 46 pages?
Yes.
And did you later cause to be prepared some pre-filed rebuttal testimony of Dr. Mark Cooper consisting of some 21 pages?
Yes.
Do you have any corrections or additions to make to either your direct or your rebuttal testimony at this time?
No.
If I were to ask you the questions contained in that direct and rebuttal testimony, would your answers be the same as given in that pre-filed direct testimony?
Yes.
Did you cause to be prepared and pre-filed exhibits to such direct testimony identified as exhibits MNC 1 through 15?
Yes.
Were such exhibits either prepared by you or of a type reasonably relied upon by experts in your field informing your opinion?
Yes.
Did you cause to be prepared pre-filed rebuttal exhibits? In 1 second. Identified as MNC rebuttal 1 through 5.
Yes.
Were such exhibits either prepared by you or of a type reasonably relied upon by experts in your field informing your opinion?
Yes.
Right, Mr. Chairman, at this time, then, I would move that the Commission accept Dr. Cooper's pre-filed direct and rebuttal testimony for inclusion in the record as if given orally from the witness stand.
Okay, Dr. Cooper's pre-filed and rebuttal testimony will be entered into the record as though given orally from the stand.
And at this time, I also move then the admission and evidence of Dr. Cooper's pre-filed direct and rebuttal exhibits.
Okay, Dr. Cooper's exhibits and pre-filed and rebuttal exhibits will be entered into the record as number 11.
Dr. Cooper, did you have occasion to prepare a summary of your direct and rebuttal testimony?
I did.
And if I could hand that to somebody who might distribute to the parties, I believe I made copies available to the Commission.
We have that. We already have it, I think. All that you need to get it anyway.
Just have a moment for folks to catch up. That would be a help. Proceed, Mr. Chairman.
Please.
Dr. Cooper, would you summarize your direct and rebuttal testimony?
Yes, I will. Mr. Chairman, members of the committee, and others in attendance. My name is Dr. Mark Cooper. I reside at 504 Highgate Terrace in Silver Spring, Maryland. I described my background and qualifications when I last testified before this commission in 2012, urging the cancellation of this project as imprudent and uneconomic as follows. I hold a PhD from Yale University and have been providing economic and policy analysis for energy and telecom for over 30 years. I'm a fellow of various universities, on specific issues, including the Institute for Energy and the Environment at Vermont Law School. I've testified over 100 times before public utility commissions in 44 jurisdictions in the U.S. and Canada on energy and telecommunications, and about twice as many times before federal agencies and Congress on a variety of issues, including energy and electricity. In the past few years, I have testified on nuclear construction cost issues before regulators and legislators at the federal and state levels in the U.S. and Canada, and published papers and articles in professional journals. Since my 2012 appearance before this Public Service Commission, I've published a book in 2017 from Prager, The Political Economy of Electricity, and a research report explaining the failure of the nuclear gamble in South Carolina. In 2018, I revisited and updated the issues raised in South Carolina in a paper entitled A Clean Slate for Vogtle, Clean Energy for Georgia. In that paper, I compared the economics of Vogtle and Summer and explained why South Carolina had done the right thing in pulling the plug on construction of Summer Units 2 and 3. When I appeared before the Commission in 2012, I was charged with reviewing and opining on the prudence of the going forward decision at that time, assuming the prudence of costs already sunk in the projects, which had been approved by the Commission, based on the utilities' glowing assurances. In this case, however, post-project abandonment, I've been asked to review and offer my expert opinion on the prudence of all project costs back to the beginning, since the utility now seeks post-abandonment recovery of all those project costs pursuant to the provisions of the BLRA. I have concluded, as explained in my direct and rebuttal testimony, that all of those nuclear project costs were imprudently incurred, given the fact known at the time by the utility and others, and given the duty of care and disclosure to the regulators expected of a reasonable utility. I put a great deal of data into the proceeding dealing with Summer 2 and 3, but in my brief comments, I will emphasize the major themes of my analysis. It is now clear that virtually all of the parties to this proceeding, except the utilities, agree that substantial portions of the cost of the abandoned Summer nuclear project were imprudently incurred, that the project should have been abandoned as imprudent at an earlier date, and that charging ratepayers for such imprudently incurred abandoned project costs should be disallowed by the Commission. The non-utility parties differ only on the date after which such imprudent costs should be disallowed, as triggered by the recently disclosed internal utility records reflecting such overwhelming imprudence. The existence of such secret internal documents reflect a fundamental failure by the utility to honor its duty of disclosure to the regulators, ORS and the Commission, of the material information regarding the nuclear project needed to assure effective regulatory oversight and consumer protection. That duty of disclosure is imposed generally by the accepted principles of utility regulation, as well as by the Baseload Review Act and other statutes. ORS has concluded that such conduct by SCE&G is, in abusing its duty of disclosure to regulators, amounted to fraud and imprudence as expressly defined by the amended BLRA. The ORS and intervening parties differ only on the date when such utility imprudence should trigger abandonment project disallowance. My clients, Friends of the Earth and Sierra Club, have contended from the very inception of the project in 2008 that it was an imprudent and reckless gamble and the facts known at the time to the utility generally demonstrated that the project would fail to deliver its promised economies compared to far less risky, cheaper, or less costly alternatives. In short, there are four bases to disallow costs, any one of which alone could support the finding of imprudence. Combined, they present an overwhelmingly clear case for cost disallowance: mismanagement of the project, misrepresentation of the chaos in the construction process, misunderstanding of the economic reality in the electricity sector, and misinterpretation of the Baseload Review Act. As evidence of the problem mounted, the utility repeatedly failed to fully inform the PSC. Past decisions to allow cost overruns were made under false pretenses, actions that hid material information from the PSC. In my 2012 testimony, I pointed to independent third-party analyses and widely available counts, as well as my own analysis of the cost of power from new nuclear reactors, to show that nuclear power was uneconomic. The publicly available data from that period about the severe problems of construction and costs of Summer 2 and 3 have now been corroborated by internal private documents in the possession of the utility, documents and concerns that were never shared with the Public Service Commission. Thus, my position and the position of my clients were not a case of 20/20 hindsight. They are an example of reasonable foresight that the utilities should have exercised and the PSC could have enforced if it had been told the whole truth. Information was available to the utility prior to the inception of the project and confirmed by severe problems that immediately presented themselves as construction ramped up. Information that could have allowed the utility to completely avoid incurring all subsequent imprudent costs. The decision to abandon construction of the plant should have been taken at the very beginning and not 10 years later when the utility belatedly chose to abandon the failed project. The withholding of information is in itself an imprudent behavior and reinforces the overall pattern of imprudence. Given the utility's disregard for the obligation to behave in a prudent manner and its misunderstanding of the BLRA, it is all the more clear that the imprudence reaches back to the very beginning of the project. In my 2012 testimony, I pointed out that, quote, advanced cost recovery under the BLRA gives nuclear costs very special treatment, but it is not a blank check, and it does not diminish the obligation of the utility to ensure that it delivers the least cost electricity to ratepayers, close quote. Unfortunately, the utility made the mistake of thinking that the BLRA gave it an ironclad recovery of ex-ante approved costs. No matter how poorly the utility performed or how badly it behaved, even if, as the case here, it broke the law, and even if, as the case here, the utility failed to fulfill its obligation to inform the Commission of the true state of the project, their presumption is illogical and their behavior is illegal. A mountain of publicly available evidence that nuclear reactor construction was uneconomic warranted rejection of this foolish project as imprudent from the outset, had the utility honestly disclosed the known risks to regulators. My 2012 testimony demonstrated the evidence of imprudence. Coupled with the mounting evidence of significant early problems in the construction of the Westinghouse AP1000, it warranted project cancellation. Secret documents that the utility was recently forced to divulge as a result of the battle over abandonment now make clear that the utility actively suppressed disclosure of the evidence of imprudence from regulators. Such evidence of imprudence and withholding of material information from ORS, and this Commission demands full disallowance of the costs of the abandoned nuclear project. Thank you.
Mr. Chairman, Dr. Cooper is available for examination by other parties in this commission.
Thank you. Okay. ORS, any questions? Thank you. Mr. Knapp? Walmart? We're going to call the roll this time. We'll get a little more streamlined later. I just like to say y'all's names. United States Department of Defense. Thank you. Ms. Teague.
No questions, thank you.
Speakers.
No question.
Central Electric Power and Electric Cooperatives.
No questions, Mr. Chairman.
Okay. Coastal Conservation League.
No questions, Your Honor.
Thank you. ARP. No questions. Energy Users. Sure. Mr. Elliott.
Dr. Cooper, nice to see you again.
Nice to be back.
You have you offer some intriguing testimony on page 12 of your direct testimony. Excuse me, on page 10 of your direct testimony, where you testify that the used and useful principle embodied in the BLRA itself, where the statute recognizes but limits the advanced cost recovery to circumstances where the utility is actively constructing the plant in accordance with the construction budget and schedule approved by the commission. Do you recall that testimony?
Yes, I have it.
And you reference, with respect to that testimony, Section 58-33-275C. Do you recall that?
Yes, I have it.
Well, you raise an intriguing point, and could I ask you to elaborate on that, on the concept of used and useful with respect to 275C, please?
Well, so used and useful is straightforward, and it's the normal course in our capitalist economy. And I am, if you see the subtitle of my book, a devout capitalist, a progressive capitalist, but nevertheless a devout capitalist. And the principle is the following, and I frequently do this with a shoe store. If I walk into a shoe store and buy a new pair of shoes, and I really like them, what I'll do is I'll put the new pair of shoes on, and I say, put the old ones in the box, and they'll scan the label on the box. But I get the use of that product when I buy it. And almost everything we do in our economy works that way. Now, there's a few layaway plans here and there where we pay in advance, but by and large, all the transactions occur, the product is used and useful, and I pay for it. And the risk is taken by the capitalist. They have bought the material, built the factory, manufactured, distributed, so they bear the risk and they get a return on that. That's the way it's supposed to work. So, and that's the utility principle. The general principle is people don't pay for generation of facilities until it's used and useful. Here we have this shift where the commission is asked to make certain decisions before the product is used and useful. Tremendous advantage. Let's be clear. It was a tremendous incentive to the utility. But in my reading of the statute, that didn't mean that no matter what they did between the time you said go ahead and the time they brought it online, no matter how badly they behaved, they were guaranteed every penny. That doesn't make any sense. So it was a violation of the used and useful principle, but there was a continuation of protections in the statute so that you were going to look at it again and make sure they had conducted themselves in a prudent manner. And I think that sort of is the core of my view of what went on here.
All right, very fine, sir. And would it be fair to say that the used and useful principle is embodied in Section 275 in the sense that as long as the plants are constructed at cost and on schedule, those costs would be recoverable under the BLRA?
They would be recoverable, but let's be clear. I believe that under the BLRA, there would still be an examination of how well or poorly the utility performed. But they would be recoverable, and that was the advantage of saying, well, maybe the scale is tipped over this way, but that didn't mean this commission would never look at their behavior.
Thank you. Now, I heard Mr. Ziegler a moment ago state to the commission that there is an ongoing question about the applicability of Section 58-33-220 of our code as was amended by the General Assembly this summer. And let me direct your attention to page 13 of your direct testimony.
I have it.
Now, you testify that because you studied this and you made an analysis, that the General Assembly codified certain concepts with respect to prudence and imprudence. Was that your testimony?
Yes, that is my testimony, is that they codified them in a way that was consistent with what the law meant at the time. Now, why would they come later and say, wait a minute, there was a misunderstanding here? And that's the way I view that, is saying, we never said this commission had to be deaf, dumb, and blind if you went off and committed fraud and mismanagement. No, that's not what they meant. So I believe that's what they were doing here.
Well, and would you agree with me that under what I would call traditional concepts of prudence, that this company could not defraud the Public Service Commission before the General Assembly codified that provision here in Section 220?
I believe they could not, yes. It was illogical to assume that they could.
And again, do you agree with me that these definitions of prudence and imprudence really simply codify existing concepts of prudency under what I consider traditional rate making?
Here in South Carolina and elsewhere, yes, they are very traditional definitions.
Now, you've got a nice quote in your direct testimony on page 15, and I draw your attention to it. And you describe it as you describe it thusly: in the judicial review of the Commission's 2012 cost overrun case, all parties agreed that the opinion of the Georgia Appeals Court set forth in the accepted definition of the terms, ironically, in the context of reviewing cost overruns in the 1980s construction of the first Unit 1 at Plant Vogel. You recall that testimony?
Yes, I have it.
All right. And you understand that actually, while all parties agreed that that definition was the existing definition of prudence, you understand that was SCE&G's quotation in their brief before the Supreme Court.
Yes, it became very famous here. Yes.
All right. And so I would ask you, sir, under traditional concepts of rate making, prior to the amendment of the statute, do you agree that the concept of prudence implies a standard or duty of care owed to others?
Absolutely, which is what the capitalist owes to the consumer and the market imposes on him. That's exactly why we do it that.
All right, sir. And would you agree that under traditional concepts of rate making and prior to the amendment of the statute, Section 220, that in building a nuclear power plant, the utility must exercise a high standard of care in order to protect the public health and safety?
Yes, and I think that the interesting thing is that as we've now begun to look at the fabric of what went on, this commission made it very clear, I believe it was the first order, that said the utility was under an obligation to tell us everything, because the legislation had placed a new burden on you. It was a burden. It didn't let you off the hook. It meant you had to work harder. And as I have now discovered, that first decision said, you guys have to really tell us everything. Because you knew, the PSC knew this was going to be a heavy burden. And so that is exactly it simply took forward some key principles while it gave some clear incentives to the utility.
Thank you. And finally, would you agree with me that under traditional concepts of rate making and prior to the enactment of the amendments to 220, that under a prudency standard, while the standard to be applied is reasonableness under the circumstances, where the risk of harm to the public and the ratepayer is greater, the standard of care expected from the reasonable person is higher? Would you agree with that?
I will agree with it, but I don't even think you need it. I mean, it is the case that these huge projects are very important, but the principle is very, very clear. There is a very high standard of care, precisely because we have given up on the marketplace, we have put a regulatory commission in its place, and in doing that, we know we have to do consumer protection. And so there is a very high standard of care here.
And that standard existed before the General Assembly enacted
it. It existed in the BLRA, in my opinion.
Thank you. Now, on page 16 of your direct testimony, you testify that, and referencing back to the 2012 testimony, quote, while the BLRA represented a dramatic change in the way rates were set for new nuclear reactors in South Carolina, it did not abandon the fundamental concepts of just, reasonable, and prudent that govern the setting of rates. Do you recall that?
I recall that. I have.
Now, what I'd like you to elaborate on for me and the Commission is what you meant by the BLRA represented a dramatic change from what I call traditional concepts of rate making.
Well, the first one is used and useful. This commission would not normally opine on expenses until they were expended and the customer was getting the benefit of a facility that was used and useful. So that's a tremendous change. There were and that gives an incentive. So now you have this beginning statement of, yes, go ahead and do it. But what that act never did was it never changed the obligation to be prudent. And so that's the difference. And there were other incentives in the law, but that's the key one here. Sidestepping used and useful is a big change. And everyone knew it was a big deal, and this commission knew it was a big deal in 2009. And the company I believe the company misinterpreted the statute, and that's why the legislature acted again.
Now, Dr. Cooper, I've not been around as long as Mr. Guild here.
Oh, that hurt.
And so I wasn't present at any of the proceedings in the 70s and 80s, but I understand, based on your experience, your knowledge, your background, and your education, you are familiar with the nuclear rate proceedings of the 70s and 80s across the country, correct?
I actually testified. The first regulatory commission I ever testified before was on Grand Gulf 2.
Wonderful.
1982, I believe.
So tell me, please, if I am correct when I describe those proceedings as requiring the company to start constructing a nuclear reactor on its own dime and then coming before a Public Service Commission seeking recovery of those costs. Is that the way those cases would have come down?
No, ultimately that's what those cases came down, and a large number of disallowances took place. But there was also another process that went on in the 70s, which has now come up in this, in my my direct testimony, which is what I called back then, discovered, was the to-go scam. Because what the utilities did was they came in and said, well, this is going to cost us X, and under our integrated resource plan or our planning process, it's less costly than anything else. So they said, we're going to build it. And they would build it. Now, the costs weren't improved, but they told the commission they were going to do it. And then 18 months later, they came back and said, uh-oh, it's 2X. But because we've sunk so much in the cost in the project already, it's still cheaper than going forward. So they said, we'll go again. And 18 months later, they came back again and said, oh, it's 2X again. And this went on for most of the 70s. And then at the end of the period, the commission said, no more uh-ohs. Future cost overruns are at your risk. Half of the orders were canceled instantaneously because there was no more automatic cost plus. So in one sense, it was the old style, but there was also a process wherein the utility tried to get the regulators to buy in with the to-go scam, and ultimately it ended. And you saw a bit of that here, right? We can start to get cost overruns, and every time they get nervous, they formally would come in and say, approve this stuff. Because they're getting nervous, and as I point out in my testimony, you could see other indications that they were getting nervous about it. In my opinion, this commission should have said no. Had they had all the information, I believe they certainly would have said no. But the process was not all that different from the way it had been, both in general terms of prudence and in the specific history of the nuclear industry.
But it would be fair to say, would it not, that a drastic change with respect to the BLRA from traditional concepts of rate making is, traditionally the company would have to invest its own funds, and under the BLRA the company got to invest the ratepayer funds.
The ratepayers bore the risk of the early expenditures.
All right, here. And another drastic change is the concept of the early prudency decision in the BLRA versus the concept of proving prudency under traditional forms of rate making, correct?
Yes.
And here there's...
But let's be clear. I don't believe that the BLRA gave up the last review, because there was always a question of what happens if they committed fraud? What happens if someone embezzled the money? Under those circumstances, do we have to pay? There was always the possibility of asking this question of, wait, how bad or poorly had the utility performed? I think that question always existed.
And I don't disagree, but under traditional concepts of rate making, as I understand it, Mr. Guild would be in every time there was a rate case filed by SC&G when they were building their first unit, and Mr. Guild would be able to raise the prudency issue in every rate case, correct?
Absolutely.
And that's a drastic change from the BLRA, correct?
That's the difference between ex ante and ex post.
Now, you make a statement on page 40 of your direct. At lines 15 and 16, and you state, it now turns out that in order to maintain the fiction of prudence, the utility had to hide the facts from the commission and ultimately cook the books. Do you see that sentence?
Yeah.
Please explain that.
Well, cooking the books is a little bit of a colorful term, but I think it is correct. And I was on the stand at the time and I produced evidence publicly available where people had now noticed that as the AP 1000 ramped up, it was very hard. It wasn't working. So there were headlines all over the place. And I testified to that. So that was information that was available to the utility. And if you go back and look at that definition of prudence, they talk about information available. Now, that's an important distinction because prudence involves not only what the utility knew, but what the utility could and should have known. Ignorance is not a defense for bad outcomes. If the utility should have known and could have known, then you can disallow costs. And so cooking the books is essentially when you are standing there with, we now know, a huge number of really damaging hassles, blocks, stop work, all kinds of things going on, preventing them from actually building the darn thing. And you come in and say, oh, those are just risks and we told you about them. But you never conveyed the extent of that. To me, that's cooking the books.
Very fine. Let me direct your attention, if I may, to your rebuttal testimony at page 4. Line 3.
I have it.
Yes, sir. And if you were here a moment ago, you heard Mr. Ziegler stand up and remind the commission that the company view is that these 13 or however many of these orders there were under the BLRA were dispositive of the issue here. And you testify the claim that the PSC approved the costs along the way and therefore costs cannot now be disallowed is bogus and should be rejected by the commission. Would you explain what you mean, please?
Well, and again, you go back to 2012, and there was a great deal of evidence available to the utility, to me, that there were very, very severe problems. And we now know, with letters from the CEO to the vendor, that outlining the inability to deliver the modules, for instance, which was absolutely critical, I don't think that was conveyed to this commission. They certainly didn't obey the 2009 order where it says, tell us everything. Well, that letter and all those problems, which we now know existed in 10 and 11, should have been reported to the commission. And I don't think they were. Now, it was later that the utility raised it with the vendor. But we know those problems were ongoing. And what happened when the plant was abandoned was that a lot of people came forward and began describing the kinds of problems that existed. And so when I testified on my direct testimony, I relied on that publicly available information. Lo and behold, once we start to see the private unsealed information, those problems were known to the utility, and they should have been made known to the commission. So that's why I believe those decisions were bogus in the sense that they were tainted by the failure to disclose.
Thank you. Now, if I understood, and I think it's Mr. Balzer, if I understood Mr. Balzer's opening correctly, the company will plan to blame everybody in this room except itself for this disaster. And I, like you, infer from the argument and the company's testimony that the company tends to blame the commission for where we are today. On page 4, line 14 of your testimony, you testify the claim that the commission should have been able to overcome or decipher the obfuscation in which the utility engaged is equally bogus. You recall testifying to that?
Yes.
Would you please explain your answer?
Well, and this is the classic case. This commission has a limited set of resources. They have a certain authorities. The company's got the data. And so if you look at the way proceedings go, they have the data. They're required to deliver it to the commission, the staff. And so the notion that saying, well, you could have found this out, and we now heard today that, well, the ORS people were down there. Why didn't they realize what was going on? Well, the company knew what was going on. And that's the point of they've got the data. And saying, well, they could have figured it out. And the answer is that's not the way it works, because they own the data. And they made it clear until very recently they intended to own it privately. But now it's public. And that's always the way this works. The companies have to put forward the data, and sometimes they get to protect it, and sometimes they don't. But we don't assume that the staff can figure it out if they cannot get it from the companies. They were not given it by the company.
Dr. Cooper, you've been great. Thank you for your testimony.
Thank you. Attorney General's office. Thank you, sir. Solar Business Alliance and Southern Current.
No question.
Public Service Authority, South Carolina Public Service Authority.
No questions, Mr. Chairman.
South Carolina Electric and Gas.
We have no questions of this witness.
Minion.
No questions, Mr. Chairman.
Commissioners, questions?
Chairman.
Commissioner Hamilton.
Thank you, Mr. Chairman. Mr. Cooper, happy to have you back with us again, Dr. Cooper. And Dr. Cooper, are you aware how this commission was reconstructed in 2004?
I have not studied that.
Okay, well, let me just give you a brief overview of the situation. At that time, this commission in the past had about 100 employees. We were able to do all the investigative work that we do, did the auditing, transportation, all these things were under this roof. In 2004, we were reconstructed, and the Office of Regulatory Staff was formed, and they were given the authority to do all investigation. They were given the authority to bring all the information to the commission. They had the authority under the Base Load Review Act to have 3 people on site at all times to keep us informed. We were under a wall with about 25 people that work here, and we could do no investigation work. We had attempted one time to visit the site, and we were denied that. We could not do under the laws that were in effect. They said we could not do that. So what we had to do was wait for all of the information to come to us that was brought to us by the company and by ORS. That is how we had to make our decisions. ORS in all of these instances, with their witnesses in whole, always told us that everything was fine, all the expenses were prudent, and that we should go forward with the rate increase. So this has been where we have been during that period of time. And I know what you've told us today has been valuable information for us. But you were here before, and all we could depend on was what the final decision was. It came in from the stipulations that, and most times they had a settlement. In fact, I think in all cases, there were a settlement that was given to this commission that all parties involved, basically, with the exception of a few, had always agreed to.
Well, I understand that, and you've described the spot that this commission is in. You are really dependent on the company and then filtered through the staff. But think about the exercise of if all of those problems identified in the 2014 CEO letter, but they existed in 10 and 11. If those details, I don't believe those details were made available to the ORS. They might have been on the site and they can see a few things, but I don't think those details were made available to the ORS. You heard the Bechtel. Everybody's running around trying to run away from Bechtel. That was never disclosed to the ORS, right? And so the utility was not forthcoming. And that made it, and you can't say ORS should have figured that out on their own.
I'm not trying to say
I understand that, but I'm just, and of course you, as I agree with you, you have to opine based upon what they said, but you also heard other evidence. And I was here in 2012, and to me, it's remarkable how closely what I said in 2012 is reflected in that CEO letter. I mean, that's what really got me going, because I could know that on the basis of publicly available information, which means that a utility who's expert and obligated should certainly have known that. And it turns out they did, but they didn't tell anybody.
Right. I think you got it right. Let me ask you one other question. If we have a change in Congress this year, do you think the air pollution laws will be changed?
I better recuse myself from that question since I'm in proceedings in court cases to argue that you can't. And let me give you an example, okay? It's the one we filed comments just this week on the fuel economy standards. And the new National Highway Traffic Safety Administration and the Environmental Protection Agency have said, well, you know, we think we've solved our energy insecurity problem. We don't need conservation anymore. Now, Congress just enacted an update of that, and they embraced it in 2008. It's not like it's the old New Deal. This is recent stuff. And it may or may not be true that things have gotten better. It turns out they've gotten better because of all the conservation we've done. But that's not the job of the agency to change the goals of the nation. And so if the Congress flips, I don't think, and if you look at the clean air, take clean air, they did not withdraw the endangerment finding. Right? They left it. Now, a lot of people wanted to do it, but that is a heavy lift. And so there are certain principles enacted in law, and that's under the Clean Air Act. We have the Energy Policy Conservation Act. Those are principles enshrined in law, and administrations come and go, and some try and push hard one way, some try and push hard the other way, but those principles kind of hold. And I think we'll end up with a significant amount of principles binding. And I've been to court lots of times, but we'll see. You never can tell exactly where the courts are going to end up.
Dr. Cooper, I appreciate your testimony. Happy to have you with us, sir. Thank you, Mr.
Thank you, Commissioner Hamilton. Commissioner Howard.
Good afternoon, Dr. Cooper. Glad to have you with us. A couple things. We'll follow up on Commissioner Hamilton. Does the Sierra Club advocate for and support new air admission legislation?
I'm not. I'm an expert on this stuff. I don't know what their policy is on that.
Well, I thought I'd ask. You mentioned, in your summary, you mentioned 4 bases for disallowing cost.
Yes.
On page 3 of summary, but of the 4, I guess I got a grip on all, but I'm curiosity about the second one, misrepresentation of chaos in the construction process. Would you explain that to me?
Again, if you go, if you look at the history of the industry, which I have, and I hate to admit I first testified in 1982, so I'm older than any of these guys. If you look at the history, it was just very, very difficult to build these things. And the AP 1000 came along and they said, we're going to make it easier. And there are lots of people said, there's no reason to believe they're going to make it easier. And that was in my 2012 testimony. But then what happened is we had this modular design which was going to solve all the problems, and it didn't. So get that CEO letter and go back and look at the dates at which they started to notice that they couldn't produce modules that were past the standards. And the NRC was not that tough, right? So what happened is that they couldn't deliver the modules. Well, you can't deliver the modules with other stuff you can't. It's such a complex process. It cascades, right? And so you go back to 2010, and which is the minute they were ramping up and starting to spend serious dollars on construction, and they were having trouble. And the trouble just never went away, and it got worse and worse. And I think it may be in that ORS chart where you can see the complaints about how many modules weren't delivered, and then the hypothesis of, well, what would it take to catch up? And you heard an explanation of, well, we think we should just pressure them to try and catch up. Well, frankly, there was no reason to believe they could possibly do it. And so that's what I mean by the chaos. But from the very beginning, I mean, in Georgia, they couldn't dig a hole. If you remember the mud mat, right? You need to have a mud mat. And they had to dig the hole, right? And they dug the hole, and they didn't have enough backfill. And they went to NRC and said, we want to import mud from someplace else. And when the NRC makes them nervous because they want the same ground, right? So they couldn't even dig the hole without getting into a trouble. And then they put in the rebars in, and they weren't to specifications, so they had to do the rebars. And that's the easy stuff. That's just pouring concrete and digging holes. Now you get into the complex stuff, and they couldn't deliver it. Read those memos, and you'll see they couldn't deliver it, and a prudent manager would have said, you guys can't do this. We should stop. And obviously, Santee Cooper began to scream at them about that early on.
Another question. In traditional rate making, is the used and useful principle backed by any statutes?
I assume it is in the statutes. Now, it could well be in the founding principles adopted by the regulation. That is, you create the regulatory body, and they will articulate a set of principles. Clearly, prudence is in the statutes. I would assume that the concept of used and useful is the cornerstone of the way you determine prudence. Ratepayers don't pay for things until they have the advantage. They don't pay for the shoes until they can put them on.
I understand that. Thank you, Dr. Cooper. Thank you, Mr. Chairman.
Thank you. Commissioner Elam.
Thank you, Mr. Chairman. Good afternoon, Dr. Cooper. I want to draw a little bit on your experience of those construction projects in the 70s and 80s. Sitting up here, I can break that rule about a lawyer not asking questions that he doesn't already know the answer to. Talk to me a little bit about the role in those projects of construction work in progress.
Well, construction work in progress was to put it in modern terms, the Darth Vader of the consumer movement. I mean, consumers hated the idea of construction work in progress precisely because it shifted risk.
And describe what it is, please.
Well, what utilities would love to do is they would love to have you pay for things as they move along without any guarantee that they'll ever finish.
And the use of construction work in progress, CWIP, was really a hot issue in the 70s and 80s.
It was a hot issue, and I do not believe there were any statutes like the BLRA to tip the traditional balance.
It mandated QIP.
It mandated, as I've described here, it mandated the utility, the commission would say, go ahead. But I've described to you that the Middle South system was doing the same thing with Grand Gulf. They would come in every now and then and say, our costs are higher. But they weren't collecting. But they just were telling the commission because they understood that someone could come along when they tried to collect and say, you could have built, at that time, it was a coal plant or a gas plant. They said, you could have built a gas plant for half that. And at the end of the process, it would have been disallowed. So utilities would love to get buy-in. And what happened here, as you read the record, is that the utility thought they had an absolute buy-in. So that once you said, go ahead, you could never look back and say, hey, there's fraud there.
Okay.
And I don't accept that.
Okay, you said utilities coming back. Explain how that process worked in one of these projects. Utilities would periodically come back and ask for more recovery through that?
No, I don't. That was not the case in Mississippi. I do not believe it was the case in Mississippi, and I will do that subject to check.
Okay.
What was going on is that, this was the early start of an industry. They had only built a few small reactors. They're all done turnkey projects in which the vendors, one of whom was Westinghouse, never told people what it actually cost to build the darn thing. They just built them because they were hoping to get more business. They signed all these cost-plus contracts. So I think the utility, it may have been part of a resource planning process. I need to go back and look. You've now asked a question, so I want to say the subject to check. But so the utility kept reminding or telling the commission that this was the least cost thing to do. And I will tell you that I was a witness, as I say, it was my first case, and the company witness, he said to me, you can never beat me in the to-go analysis. And that's when I really dug into Grand Gulf. So this is before TMI. This is the first decade, right? And what you saw was this constant process of coming in and raising the cost estimate.
Okay. And is that what made CWIP Darth Vader, that it was just raising costs?
It would have raised, if you had QUIP, you would be collecting that money. And once you collect that money, you then have this sunk cost problem, which I analyzed in 2012 and concluded that it was still cheap in 2012. So what happens, you spend $1 billion, and someone comes in and says, $1 billion, you got $1 billion to go, I can get a gas plant for $1.5 billion. They say, but you have to pay me my sunk cost, so your cost is $2.5 billion. And so they would, if you have QUIP, you lock in that high cost choice.
Okay. Now, after 3 Mile Island, or for whatever other reason, when all these projects were canceled, what happened to QUIP recovery after that?
Well, there were, as I say, no new reactor was ordered after 78 until Vogel and Summer. So new orders stopped. Half of the existing orders were canceled. Some of them might never have been memorialized in contracts, but they were at least 125 were canceled. Now you had a series, so you had a bunch of plants in a variety of different statuses of disrepair. You had a bunch of plants that were abandoned, and there were big proceedings about abandonment costs, but they had not collected for those plants. So we had proceedings about what are we going to do with these abandonment costs. Then you had a series of plants that came online, but had significant disallowances. And this was, again, the traditional way of once you turn it on, then we figure it out. The utilities always wanted QUIP because it shifted the risk. So the reason you didn't want QUIP was precisely because it changed that dynamic. That's what the advanced BLRA did here. It changed the dynamic, but it's quite clear. Abandonment all of a sudden moves you into a different realm, but I still believe, even if they had finished, this commission would have had the obligation to look at how well they had actually spent the money. There was no way that the legislature meant that whatever they spent, you have to pay. So this commission would have had that obligation.
Okay, thank you. Nothing further.
Thank you. Commissioner Whitfield.
Thank you, Mr. Chairman. Good to have you with us again, Dr. Cooper. Want to build just a little bit on what stand a little bit on what Commissioner Hamilton said. I'm not going to reiterate all of that other than to say, of course, this commission is bound by South Carolina Act 175 and the Judicial Code of Conduct. And unlike many other NARUC states and 50 states, we are not allowed to go to the site. We are not allowed to do a lot of things that a lot of other commissions can do. So with that, I'm going to go a step further, talk about the Baseload Review Act. And I liked your analogy about the shoes and used and useful. It's a simple analogy that even a rural boy from South Carolina gets. and certainly appreciate you boiling it down like that and putting it in that perspective. But based on what you've testified, and you testified in the 2012 proceeding, and Ms. Brockway testified in the 2008 proceeding. You weren't here for that one, but your attorney, Mr. Guile, his voice, I always tell him, is very audible. And one of the things he said is, you're giving SCE&G a blank check. The train will have left the station. He said that in 2008. Based on that, and your expert opinion, based on that, and what you're saying that has been withheld from ORS, and therefore withheld from this commission, and a lot of these proceedings were not, the increases we're talking about, were not full-blown proceedings like the one you testified in 2012. In your expert opinion, what other decisions what other outcomes could there have been?
Well, first, let me say, Mr. Guile is prone to a little excitement, and so I disagree with the blank check part, and I wasn't his witness in 2008. I'm an economist, he's a lawyer, and I would have educated him. But for me, we didn't go back, but when I start to see this stuff, and especially now we've got all this data, I remember that 2012 proceeding, in which I didn't have access. I had only the publicly available stuff. And so for me, it just affirmed what the utility should have known. And it's interesting, ORS, and it dawned on me, and I mentioned that to them, they said the utility knew. Prudence involves not only what the utility knew, but what they should have known. And that's really important difference. It's a broader concept, but it's really important. So what would, and I can go back and read that George Lang, what would a regional person have done based upon the available information? Didn't say the information the utility had, the available information. And so for me, that's really important. So, and it's an interesting question. You're elected commissioners, and you're not allowed to go to the site, and you can tell me that is a constraint. That may actually be insulation. I don't let anybody tell you that it's wrong. It's different, and it would take a really interesting study to figure out which way is better. So the point is that if you look at what they knew, what they should have known, what I knew in 2012, you could have certainly reached a different conclusion. You could have certainly done at $1 billion spent what Georgia finally did at $27 billion and said, you have to be responsible for all cost overrun. Now, so imagine if you had said in 2012, all cost overruns are on your nickel. They would have abandoned the project in the blink of an eye, because I know what they knew in those private documents. So yeah, there are different outcomes that could have happened if you had had the whole truth.
Well, thank you, Dr. Cooper. And to follow that up, since you testified in the 2012 proceeding, in 2016 we had the fixed price option contract, and a lot of things were promised. One, there wouldn't be another rate case until Unit 2 was online and in service. We also, a penny over $7.65 billion would not be absorbed by the customers of SCG, the ratepayers, nor would they be absorbed by the shareholders. They were to be eaten by Westinghouse, and we all know what happened there. Yeah. Other thing, we were told that the project would go forward, whether Westinghouse went into bankruptcy or not. So there were some, if you will, guarantees or assurances in that case. Of course, it was prior to the bankruptcy of Westinghouse. So,
yeah, and look, Westinghouse went bankrupt exactly because they couldn't do it. The parent company was not willing to have the exposure. And we'll debate about whether they drove a hard enough bargain or whether they put the money to good use. But they simply said, we cannot bet our company on the ability of this entity to build a reactor, because so they were unwilling to bet the farm on the AP 1000. They were unwilling to bet the farm on the AP 1000, and they couldn't figure out when they would finish the darn thing anyway. They might have made some commitment, but you look at the scheduling, and it was pandemonium. They had no idea whether they could finish it. So, though that agreement, and everyone in this proceeding agrees that those late agreements were not worth the paper they were written on because so much had been withheld. My point is that the utility knew so much more so long ago that they should have, and if they had told you, you might have said, here's the deal, fixed cost. If you had said fixed cost in 2012, Westinghouse would have walked. If they had any brains, because they were on the stop work and all this other stuff. So, yeah, you could have changed the outcome if you had had the whole truth.
Well, thank you for your answers, Dr. Cooper, and thank you for your testimony. Thank you for being with us. That's all I have, Mr. Chairman.
Thank you. Any other questions, commissioners? Okay, Mr. Gile, any redirect?
No, sir, no redirect.
I really wish we'd have had the live stream camera shot from over my shoulder when he was talking about schooling you a little bit. It's a pretty good shot. Okay, any recross? No recross. I'm still learning this on the fly. So, okay. So Dr. Cooper, thank you for your testimony, and we'll let you step down. Be excused.
Mr. Chairman, may be excused, please.
Yes, we'll be excused.
Okay.
That's right.
And, Mr. Chairman, that concludes our case. Thank you.
Thank you, Mr. Gile. Okay, at this point in these proceedings, we're going to take a short break, and then when we come back, then we're going to power on through. So we'll be back in 10 minutes. Thank you.
Oh, hell no. He did it right. Well, thank you.